standard that Jeff Spence had anything to do with it. Jeff Spence has not had anybody place him in Tippah County, Mississippi on November 30th. Nobody has placed a murder weapon in his hands. They have no proof in terms of fingerprints. They have no proof in terms of any standard forensic evidence. And the question remains, as outstanding, who killed Kirby Carter? I don't think the state knows. I don't think the state will ever know. And I think when I told the jury on Monday that they selected somebody to be an accused, that's exactly what we had. We had a selected accused person, and they have to prove beyond a reasonable doubt that Jeff Spence not only is guilty, they haven't even proven that he has anything at all to do with this case. He was in Tippah County in Kirby Carpenter's home for weeks. He and his wife helping with the newborn baby. They undisputedly left Tippah County Tuesday afternoon, November 29th, arrived home in the southwest Virginia area around 2 or 3 o'clock in the morning on November 30th. We have a electronic message rendered from a conversation actually between Caitlin Spence and Karen Spence, Jeff's wife, and Caitlin's mother, at about 8 p.m. on November the 30th. The subject of that conversation is what Dad had been doing today. He's worked in the yard, he's worked inside, he's grilling hamburgers. Apparently he's good at hamburger grilling, and the next sentence from Caitlin is, well, I know how much you've missed his hamburgers because they've been in Mississippi so much. The conversation is obviously about Jeff Spence, and he just got up from a nap and worked hard all day, just mixing hamburgers for supper, for dinner, because that's in response to Caitlin's question, what are y'all having for dinner? That place is, he's not cooking dinner at Kirby Carpenter's house, he's cooking dinner in his own house in Virginia. There's just nothing to tie him at the opposite time here. He didn't cook dinner in Virginia around 8 o'clock and kill Kirby Carpenter at 7 o'clock. It's just not possible. It's too far. It's 800 miles, 10 hours. That's the thing. Other proof is like the trash we just got through hearing from a strange daughter full of animosity and hate. Doesn't mean that she didn't place it. What she's talking about is 10 years ago, not now, not 2022. And other than her, they don't have any witnesses that ties to the property, ties to the deed, ties to anything, ties to this case. It's a case that merits not going to the jury, and I'm asking the court to give us a correct verdict.
Okay. Not here from state.
No, we state submits that we prove the case. Court obviously has to take this in the light most favorable to the state. And we've had testimony that contradicts everything that Mr. Hill has said, primarily through Caitlin, who had a conversation with the father, where he admitted to her that he killed Kirby Carpenter. Not only that, but we have Kirby's property in his possession, custody, and control. And, taking all the proof in the light favorable to the state, with all the testimony that has occurred, the investigation, the witnesses that have taken the stand, this man stands before the court as the state has proven each and every element of the crime.
All right. Every time I have a criminal trial, I make me a checklist of what elements there must be proof of, and I've done so in this case. I think the state has made a prima facie case as to meets all those elements. They've ID'd the defendant, they've established venue, they've established that Kirby Carpenter was living, and they established that Kirby Carpenter died, and when that took place, it was a result of a shooting, and there's evidence of a robbery had been set forth, and I'm going to deny your motion for a directed verdict. There's been some evidence on every element of the crime charge, and it'll be up to the jury to decide if that some evidence is enough evidence. And we will that'll be the jury to make this determination. Do you need a minute to y'all talk and decide how you want me to proceed as far as the defense case? Okay. Do what?
We'll do so right now.
Y'all do that now anyway, okay? Decision. However, that you were given to testify, I can't. District Attorney's Office, your own attorney cannot force you to testify. If you do choose not to testify, the jury will be instructed that the fact that you did not testify cannot be used as any evidence whatsoever that you were guilty of any crime, because we all have the right to remain silent. But whether you choose to testify or chose not to testify does not change the fact that the state bears the burden of proving that you are guilty, and you never have to prove that you're not guilty. Do you understand that?
Yes.
Have you consulted with your attorney and reached a decision on whether you wish to testify in your own defense or not?
I did consult with my attorney.
Have you made that decision?
I have.
And what is that decision?
I do not want to testify.
All right. Mr. Hill, do you agree with y'all had a discussion on that and reached that decision?
We have discussed it more than once over the past several months, more than once today, and we are on the same page.
All right.